And now to join us, we have a very special guest, Doreen Inkeles, who is a partner in the law firm of Charles Jameson. She's also a board certified marital and family attorney, and she was also involved in the Chevalier case. Doreen, are you with us?
I am. Eddie, how are you this morning?
First, you have to tell me how to actually pronounce that name, like the old actress, right?
Chevalier.
Chevalier.
Like people who remember Maurice Chevalier.
And this is a really interesting case because it's the first case I know of that has this particular holding, and I was hoping you could share some of your comments with us.
Okay. And when you say this particular holding, I want to make sure that we are on the same page. So tell me what you think the holding is.
When I read it, this looked like a very contentious post-judgment modification involving time sharing, and the court, during the pendency of that modification at an interim hearing, actually modified time sharing, terminated a parent's rights without there actually being emergent circumstances. And I am not aware of a single other case that holds that specific proposition.
Okay. Well, this was a very interesting case for sure. And I came onto the case actually rather late because this case had started sometime right before the summer of 2019. And I didn't get involved in the case until early April of 2020 after the order, which we appealed, had been rendered. So yes, it was a very contentious case. Absolutely. It was post-judgment. The mother had relocated with the children from Texas in 2014 with court permission. She actually was a pilot, which is kind of an unusual profession for a woman. And she had been a pilot for 25 years. And father resided in Texas. And at some point, the children who were teenagers, which I also found interesting in the opinion, because usually when you read an opinion, I don't really notice that the court so much mentioned the ages of the children, but in this case, they were, they surely mentioned that the kids were 15 and 17 at the time. So when the case started, they were 14 and 16. Father had started a modification proceeding because the children started to refuse time sharing. And of course, he blamed the mother, as is the case in so many of our situations, right? And there had been a hearing, which was before my time on the case in September of 19, regarding the time sharing and some therapy for the children. And while the court didn't hold mom in contempt at that particular hearing regarding the time sharing, that's where the court put in the first order, what the fourth notes on page 2 of the opinion, which is the mother shall use all reasonable means of parenting skills to enforce time sharing requirements, whatever that means. In any event, children continued to refuse time sharing. Father filed several motions for contempt. They were scheduled in March. The opinion, what I find very interesting about this opinion, aside from just the holding, is, or are really, the flags that whether the fourth intentionally or unintentionally put into the opinion, the things that they maybe thought were particularly interesting or would be looked at perhaps a later date if this were to come back. And can I just share with you a couple of them that I noticed? I don't know if you picked up on them. Is that all right? Okay.
Why we have you on, Doreen?
Okay. For example, on page 2, They talk about the mother's attorney withdrew from representing her in February 2020, and then her scheduling problems began. Well, that was an interesting little quote there, because she had asked for a continuance the day her attorney withdrew of this March 30th contempt hearing. And she explained to the court that she was scheduled to have surgery the following week because she had a very bad fall on concrete and messed up her arm and her shoulder and everything. And she was scheduled for surgery the following week. And the court said no. And the court also said, I think you have enough time to get an attorney to represent you in the March 30th hearing, or you can represent yourself, even though you're having surgery next week. So there will be no continuance, just merely because you either don't get counsel or cannot get counsel. Anyway, she had this surgery and it turned out to be a little bit more complicated and involved more procedures. So then the court notes that she asked for another continuance on March 26th and got no ruling, but was also experiencing some other medical issues on that day and did not appear at that hearing. And that hearing went forward without her. So basically, that order totally deparented the woman at a hearing she wasn't at. And it was only an hour hearing, too. Another thing that was interesting was that the court noted, relying on a 100-page social investigation report, the court found that the mother had, quote, engaged in continued interference to disrupt the minor children's relationship with the father. The social investigator was at that hearing. There was no transcript, by the way, so this order was reversed just based on the record that I put together, as opposed to there being a transcript, because opposing counsel didn't have a court reporter at that hearing. How convenient.
I don't think that was even mentioned in the opinion, that it was without transcript, was it?
It wasn't.
So that's remarkable, because the only way to win on that type of an appeal is to show error of law on the face of the order. So excellent job.
Correct.
Doreen.
On the face of the order and in the record. So when I looked at the order, I knew it was problematic right away. And then once you simply delved into the record, meaning all of the court filings, and basically put the pieces of the puzzle together, you saw exactly what happened. And what happened wasn't good, because she was pro se from February until she hired me in April. And sometimes advantage is taken of pro se litigants. Let's just put it that way, okay? So the way I read this is relying on the 100-page report to show, what the quote was. That said to me, you know what, court? If you are going to rely on this 100-page report for this conclusion, then that evidence better be in the report. Now, certainly at that time, the merits of the report were not subject to review. But to me, this is just kind of a flag that says to me, if it comes back and we have to look at this and we have to look at that report, we want to see the evidence in the report that shows that. And this case is kind of near and dear to my heart, because this is kind of what happens when power and authority are abused. Because you're not going to find that in that report. You're going to find, unfortunately, 100 pages of confirmatory bias and pandering to one particular side. And this case has also really taught me about what is it? Trust but verify. And sometimes you can't trust at all. So even the most renowned of professionals who have built their reputation in the community for being straight shooters and honest and fair, conclusions based on real evidence and real investigation, either people change or, I don't know what the explanation is, but it's the conclusion that the social investigator reached is not in that report, but for the fact that she might have been particularly looking for something like that. So we might seize on this little thing here or that little thing there to formulate that conclusion, and taking things that are not fact and calling them fact. And when they come to the court, and a social investigator is saying, in fact, this happened, they have a lot of clout. They're PsyD, PhD, been around for a long time. Of course, the court, is going to trust what they say as either fact or, their opinion has to be correct. And unfortunately, that's not the case because people skew facts and things get kind of twisted, and so there's a lot of unraveling that has to be done. And then, of course, this intensive series of therapeutic steps, which the court mentions a couple of times, that's going to be very problematic because, when someone recommends go to therapy, which is actually a very long, protracted type of therapy, and then this individual, that individual, the other individual are going to determine at the end of the day if you have improved in your empathy. How do you measure that exactly? That's going to be a problem, and I would be curious to see how that may be handled in the future should there be another appellate brief.
Well,
In any
Doreen,
event.
I said you did a great job peeling back the layers of this, and the fact that you got this reversed without a transcript, I think, is amazing. And you produced some incredible results on behalf of your client. So congratulations.
Thank you very much. Unfortunately, as you notice, the opinion mentioned that there was a modification pending, and there was a modification trial coming up, like in the very near future, and which we didn't get a continuance for. So by the time, with all of the appellate work and prep for trial, you had one exhausted attorney in front of that judge and not enough time, for like 2 days for a custody modification trial is generally not enough time. But what was interesting, if we have time, I'd like to share this different interpretation, because when we got to the very last day of trial, the court had extended it for a couple of hours to give the other side a little bit more time. And that the day before that last day, the opinion came down. So that the opinion came down July 15th, and the last day of the trial, of course, was July 16th. And what was on the table during trial was they had filed a motion for commitment. After the contempt, they said she didn't comply with what she was supposed to. So they wanted to lock her up.
So you did away with an erroneous order just in the nick of time.
It was the client's first name, as you can see by the opinion, is Mary, and talk about a Hail Mary coming from the court. But what happened was we got to trial, and if you look at the end, if you look at the beginning, it says, this is a reversal of a contempt order. And then at the end, it says, to the extent that the orders on appeal modify time sharing, we reverse without prejudice to litigate that issue at a scheduled modification hearing, which we were at. And then they affirmed, a portion of the order whereby mom was actually ordered to pay the social investigator's fee for attending that contempt hearing. So opposing counsel said, well, Judge, I don't think they reversed the contempt per se. I think they just reversed the time sharing. So I think I should be allowed to continue to proceed on my commitment hearing. And I was like, oh no, this was a complete reversal.
That's
like
clear in the last paragraph, the opinion.
Yeah, reversed and remanded. But so because the judge, we were having closing arguments even the next day on July 17th, and the client was staying in Minnesota, living there for the school year, because that's where the kids were going to school at this really nice private school up there. So she had a place up in Minnesota, and a few days before the hearing, I think I had gone in on, yet another continuance. And the judge actually said, I want your client here in Florida, in your office, on the 17th for closing arguments, or at the end of closing arguments for any rulings that I may make. Gee, you're going to rule on commitment, Judge. So you want her here so that the sheriff can come and just throw the cuffs on her, and we all know where you're going with this. So luckily, the opinion came down, obviously, just in time. But what the court had said was the court wanted to do the contempt remand then. I was like, Judge, the thing just got reversed yesterday. It's not noticed for today. How can you do the remand after contempt the very next day after the opinion, and without any warning? So the judge had actually said, if you agree that the contempt part isn't reversed, then we'll just do the time sharing like we've been doing, or if the contempt has been reversed, then, and I'm unclear, then we'll just agree to disagree, and we're going to do the contempt again, right now. Yeah. Anyway, I think at some point afterwards, the judge kind of rethought that and has given them a do-over on the contempt, which is scheduled for a couple of weeks from now. So, talk about, here I walked in on the 16th thinking, got this reversed, don't have to worry about her going to jail, it's all good, deal with that another, any contempt another day, and maybe he'll just give up and go away, because he spent a lot of money. And, only to find out that, opposing counsel had this other interpretation, so that was an interesting circumstance. But look, it was a lot of work. I filed the notice of appeal, April 10th, and April 21st, because obviously we tried to vacate, because based on the Denker case, you're not going to take an order of contempt like that and not try to set it aside, or at least move to vacate first. So we did that. And, naturally, we also tried to disqualify the judge. So both of those were denied very quickly and in summary fashion. So not only did I take the appeal up to the 4th, but I also took up a petition for writ of prohibition. And like within 9 days, because I knew I had to work fast, I got them both up to the appellate court with a motion for expedited review. And so, because I wanted the appellate court to see that I was serious about this, you know, and that here's the initial brief, you know, it's ready, expedite review. So naturally, they gave the other side an opportunity to respond to the motion for expedited review. And I guess because I had filed my initial brief, they got back a 25-page response, which basically like attacked everything on the merits, but tried to couch it in a response to expedited review. And the next day, motion to expedite review is granted. So that was amusing.
That's a really cool behind the scenes tour that you gave us, Doreen, and thank you so much for your time and sharing those thoughts with us. We really appreciate it.
Well, you are very welcome, and thank you very much for having me on your program.
Thank you, Doreen.